Afternoon. We thank counsel for being willing to start 15 minutes early. The next case is Smith versus Smith, and we will hear from the appellant.
May it please the court, and good afternoon, Chief Justice Newby and Associate Justices of the North Carolina Supreme Court. My name is Greg Duke. I'm the sole practitioner in Pitt County, North Carolina, and I'm appearing on behalf of the plaintiff appellant, Ms. Carol Sperry Smith, and I would ask at the outset to reserve 5 minutes of my time should I need it. Your Honor, this case arises out of an equitable distribution judgment and order entered in Pitt County back on August 31, 2022. The parties involved were married for approximately 15 and a half years, and the court, after an approximately one-day hearing, entered a judgment and order that granted to the defendant an unequal distribution of marital property and divisible property, and it based the unequal distribution on 3 factors. Two were statutory factors, 50-20C9, 50-20C11A, which is a statutory factor, and then 50-20C12, which is a non-statutory factor. Now, what the court did was it found that the marital estate should be distributed in favor of the defendant in the case, the husband. What he received was $209,690.24, and the plaintiff in the case received a negative $7,499.20. Now, I was not the trial counsel in Pitt County, but I'm handling this on appeal. The 2 issues, Your Honors, are, and this is appealed based on a dissent entered by Judge Arrowwood, and the 2 issues were, number 1, that he felt like the trial court was bound by a written stipulation entered into by the parties, and also that the failure of the trial court to honor that stipulation that he contended or believes the party should have been bound by, that undercut one of the distributional factors that were found, specifically in finding of fact number 34. And the finding was that the defendant in the case contributed his separate monies towards the acquisition or purchasing of the marital property. Now, this particular property that is the subject of the distributional factor is on Racetrack Road in Grifton, North Carolina. The parties had another home, the actual marital home that they lived in, and it's 2323 Persnickety Lane. So we start off with the written stipulation. Now, that was actually a written stipulation. It was filed on January the 14th of 2019. The case was tried in August of 2022. So there was approximately 15 years and, over 3 years before there was any challenge to that stipulation. And what happened was the defendant filed on August 2nd, 2022, a motion to strike and set aside that stipulation. The motion was not heard pre-trial, and I will certainly represent to you candidly that at the beginning of the trial, the attorney for Ms. Smith, the plaintiff appellant, indicated in his opening statement that we don't really need to hear the motion separately from the trial. We can basically present our case, and Your Honor can decide whether that stipulation would be set aside or not. I'll also represent to you there is not any evidence at all in the transcript showing that at the trial that issue was addressed in any manner. The parties did present evidence about various things. My client, in her case in chief, did introduce into evidence that written stipulation. That was Plaintiff's Exhibit number 20, and that was introduced without any objection from the defendant in the case. So what does that stipulation say? It's a little bit awkward in wording, but it's actually three. Number one, that the plaintiff and defendant own marital property located at 2323 Persnickety Lane, Grifton, North Carolina, and 4080 Racetrack Road, Grifton, North Carolina. Now, the 4080 Racetrack Road is the subject, at least in part of this appeal. That's the central issue. Secondly, the plaintiff and defendant stipulate and agree that the value of the marital property located at 2323 Persnickety Lane, Grifton, North Carolina is valued at $247,011. Then number three, that the plaintiff and defendant stipulate and agree that the value of the marital property located at 4080 Racetrack Road, Grifton, North Carolina is valued at $46,563. So in this written stipulation, there is an agreement that both parcels of real property are in fact marital property. There's also a stipulation regarding the value. So we have that at the
marital
outset.
property, is that a factual issue? Is that a legal issue? Is it a mixed question of fact and law?
That would be a legal determination ultimately by the court.
Parties cannot stipulate to legal determinations, can they?
I believe they can stipulate as far as the classification of a particular item of property. And if you go back and look at in a pretrial order, a typical one, and certainly the one in this case, you've got a series of schedules. You've got A1, for example, which is the parties agree that the following items are marital property, that they're worth X, and that they will be distributed to whichever party they agree. So that basically takes it out of the court's province to make a determination. So I would submit.
Isn't the difference though? So if the parties actively disputed the underlying facts, they couldn't stipulate to whether something was marital or separate property. You would agree with that?
I would agree with that.
So what really the stipulation is doing is saying there's no dispute about the underlying facts of where this property came from. So presumably what they're saying is this was a home that was purchased with marital property. It's therefore part of marital property. That, in other words, just stipulating the underlying facts that lead to the legal conclusion, right?
Yes, sir. I think that is correct. But
so
here,
what if? But so that and the parties could change, could realize that they wanted to stipulate to something else.
well, and I think they can, and in fact, in this case, the defendant attempted to by filing a motion, but other than filing a motion, he didn't schedule it over the 3-year time period after it was entered. He didn't even present any evidence at the hearing as far as the reasons why he was, in essence, contesting or felt like that stipulation should be set aside. And certainly within the transcript, you will see there was testimony on that particular item of property. There was testimony about when it was acquired, and I think even my client indicated that it was acquired prior to the marriage. There's really no issue about that, and I'll be candid with the court. But the stipulation itself, and parties can stipulate about all kinds of things for all kinds of different reasons. It doesn't mean that necessarily the stipulation reflects what might be the proper legal conclusion or the factual determination. These are stipulations. Now,
So one thing I think we'll hear from your friend is that perhaps that was a stipulation of the underlying facts that led to that termination, that it was marital property, but then the parties changed their stipulation through the pretrial order.
well,
So what's your response to that?
Well, I would say that there was no change to that stipulation in the pretrial order, and you got to think about what a pretrial order is for. It's to guide the judge with what the different determinations are, what the different properties and schedules are. You can't force a party to stipulate to something that they're not in agreement with. So even in that Schedule E, the plaintiff appellant continued with her contention as to what the classification of the property was. There was no change as far as what the valuation was or who should end it. Well, there was no distributional stipulation in the written stipulation back in 2019. But when you have a pretrial order, it's simply a series of contentions. Some of these things you're going to agree to, stipulate. The court doesn't have to spend time on those at that point. Some things you're not. So we have a written stipulation that was, in every sense of the word, a written stipulation. It was signed by both parties and counsel for both parties, and that remained right up until not exactly the eve of trial, but 27 days prior to trial, some 2 years and 7 months and change.
And,
So-
and just on the point of the impact of the pretrial order, if a party can change a stipulation by putting different language in a pretrial order as when they're identifying their contentions, there wouldn't be a need for a motion to withdraw the stipulation, correct?
That would be correct, except
And isn't the point of a stipulation that you are making clear, the parties are making clear what they agree on, so that, and then they know what they need to prove or what they disagree on?
yes, ma'am, that is absolutely correct.
And so the motion, presumably the grounds for the trial court, if the trial court had a hearing or started the trial with a hearing on whether or not the stipulation is binding, that information that would be relevant to the trial court's exercise of its discretion to allow or deny the motion to withdraw the stipulation might be very different. It might be things like, what information did you have at the time you made the stipulation? What are your grounds for saying, I now, despite 2 years ago agreeing to this, I now want the stipulation to be withdrawn?
Yes, ma'am. And in fact, if you look at the case law in our state, I mean, it's very clear that you can't simply, voluntarily, for example, withdraw a stipulation. You can't fill out a piece of paper, file it with the court, and say stipulation withdrawn. That's
Now,
one
when
of
you
the-
say you can't do that,
a party.
you mean one party?
Yes, sir.
But is there any case law that says if the parties collectively come to the court and say, we stipulated this, but now we want to stipulate to this instead, that you would need to go through those factors that you use if one party wants to get out of a stipulation?
Well, that would be correct if, in fact, the Schedule E from the pretrial order is in the nature of a stipulation.
Well, and so my question is that why would your client consent to those statements in the pretrial order if your client's position was the parties have already stipulated to what these facts are? Because certainly from the trial court's perspective, that looks like the parties agreeing that there in fact is no dispute about the value, but there is a factual dispute about the underlying facts that would allow you to determine if it's marital or separate property. So why isn't that reasonable for the court to believe, oh, the parties just changed what it was that they were stipulating to?
Well, except that in the opening statements, I know that's not evidence, but Ms. Smith's trial attorney indicated to the court that that was still an issue, and the court would need to resolve that.
But I guess what I'm getting at is if the lens through which we have to look at it is what did the parties together agree to each step of the way? It seems like they agreed it was marital. The facts would mean it's marital property. Then they consented to telling the court something different. The facts mean this is a question. And then from that point on, what your client unilaterally tells the court doesn't matter anymore. It's what the parties agreed to.
Well, I don't know that really my client is required to consent to a party's contention. I mean, their contention is their own. There's no agreement that we both agree now that the stipulation is not binding. We jointly set that aside. These are contentions. One party could say or contend everything that we have in the marriage is my separate property. The opposing party doesn't have the authority or the power to say, no, you can't put that in a pretrial order. A person is free to put anything they want to in a pretrial order, whether in the end it's going to be correct or not. But the purpose, of course, in getting stipulations is to try to streamline, shorten, and certainly the courts very much favor parties being able to stipulate. There is case law that also talks about, now that's really separate from your question, is you got to look at the length of time before a party backs away from a stipulation or tries in any way to undo that stipulation. Now, there is a case, and it's cited in the Court of Appeals opinion, It's Moore versus Richard W. Farms. And in that case, what the court said is, well, a party unilaterally can't just say, I'm hereby withdrawing my written stipulation, and then that is binding. There's going to have to be the motion, there's going to have to be some evidence presented, and the party, contrary, I would submit to what my friend indicates for the defendant appellee, the burden is on that party to present sufficient evidence to the court that that stipulation ought to be set aside.
The attorney that was representing, or the attorney at trial, at the very beginning told the trial court that it didn't need, in essence, that it didn't need to rule on the motion per se, but it could listen to the evidence that was coming in and then make its decision. Is that a fair characterization?
Well, and I read it a little bit differently, Your Honor. I'm fine with the court just hearing the evidence and considering those motions or that motion in relation to those stipulations during the trial. Now, that is clear as mud, certainly, but it does evidence, I would submit, an intention to say, look, we don't have to hear this at the outset, but during the course of the trial, you can hear evidence. It's not just what the classification of the property is. In order to set aside a stipulation, you've got to look at contract principles and you've got to determine, okay, what is the basis? Is it a mutual mistake? Is it a mistake? Is it coercion? Is it duress? It just doesn't go away. A stipulation is a pretty serious thing.
And it was the defendant's motion to set aside the stipulation, correct?
Yes, ma'am, it was.
So wasn't it the defendant's obligation to say at the start of the trial if they wanted their motion ruled on that they needed to have it heard?
I would agree with that, yes, ma'am, and that certainly was not something that happened. And
So you've indicated that the trial court didn't address this disagreement, but in finding of fact 18, the trial court dealt with the disagreement head on. So are you saying because the trial court didn't say, and oh, by the way, there's also this motion to withdraw stipulation, that it needed to reference the word or the term motion for that finding of fact 18 to sufficiently deal with the issue?
Well, respectfully, I do think the trial court has a duty to go in and actually apply the rules that this court has imposed on setting aside a stipulation. You may have contrary stipulations, and I would submit in this case, a pretrial order is not a stipulation, at least as to that Schedule E item. You still have it's not an oral stipulation announced in open court. This is an actual written, signed by both parties. It was entered way back on January 14 of 2019, and this is August of 2022, and that may not be certainly the most important issue here. Certainly a lot of time went by without challenging it, but as importantly, at the very beginning of the hearing, the defendant's attorney did not push and did not say, Your Honor, we need to have a ruling on this. We need to present evidence that shows why my client wants it set aside. It's not a legitimate reason to say, my client's changed his mind.
But do I have the timing right that it's stipulation, motion to withdraw the stipulation, then the pretrial order, and then you go to trial?
There was no motion to withdraw the stipulation. I'm sorry, let me back up. There was a stipulation, yes, and there was a motion to set aside, motion to strike or set it aside. But a motion in and of itself.
Right, but my point is that comes in, then the pretrial order comes after that.
Yes, sir, that is correct.
And then you have the court at the trial hearing from the parties, just listen, hear the evidence. I mean, why is the court then looking at that pretrial order and saying, the parties have resolved this themselves. I don't need to address this issue because there was a motion to withdraw the stipulation and then the parties got together and they've agreed, I can see it here in the pretrial order, that this will just be an issue that I need to resolve. The value of the property will remain a stipulation, but the classification, I'll have to resolve some fact disputes. And why isn't that something the court could understand from the sequence of events?
I guess you have to look at it in the context, again, of what a pretrial order is. My client, the trial counsel's client at the trial, she didn't have the authority to say no, we can't enter into this. This is his contention. If she wanted to, there's no way she could say, no, this is his contention. He could say that, they have a blue elephant for a pet. Doesn't mean that she agrees with it. He's entitled to make that contention.
But wouldn't you expect, if that was counsel's view, to say, Your Honor, you can't hear this evidence. We've already entered a stipulation, and the opposing party is bound by that stipulation. These are not facts that need to be resolved at trial, and that wasn't what.
And I don't
What the
disagree.
court heard.
Sir, I don't disagree that it could have been more forcefully stated and could have been done a different way. But that doesn't change the fact that we have this stipulation out there. And the case law says you've got to do something affirmatively to set it aside or to strike it. And you got to give us a good reason.
Well,
Give
that
us
gets
a
back to my
conflict.
original question. I mean, suppose that what happened here was you have the original stipulation, and then instead of there being an motion to withdraw, the pretrial, forget all that, the parties just came in 2 years later and filed a new stipulation and said, actually, we stipulate to this, forget that. There would be no need to walk through the factors in the test to determine if the parties could do that. Would you agree?
I do agree.
And that's because the parties are the ones that have the power to decide, are we going to agree about some facts before we go to the court and tell the court, you don't have to actually resolve this fact. We'll stipulate to it.
But if you look to that, it depends on what the stipulation is. If it is my client now agreeing that that property is separate, that's one thing. That completely changes and negates the initial stipulation. But as we stipulate that I continue to believe this property is marital, and he's contending that it's not. I mean, that certainly would be a stronger argument than a pretrial order over which really the parties have very little, well, really no authority to tell a person, a party, the opposing party, that you can't contend that. Now, it'd be different, I would contend, if the trial counsel for the plaintiff had said, Judge, there is no disagreement at this point. Trial counsel made it clear. The motion is out there and rule upon it during the trial. Now, what does that mean? Does that mean you simply hear the ordinary typical evidence that you hear in equitable distribution cases? Or does that include some party getting up there, the party who wants to set aside or strike that stipulation and say, look, this is what I signed back then, but I'll tell you why I no longer stand by that stipulation and think that the court should now set it aside. And then you present evidence on that. So the court could then certainly listen to that evidence with all the other evidence, and at that point decide whether or not that stipulation should be set aside. My reading of the case law, I mean, stipulations are something that they're not easy to unstipulate to. There's a process, and you've got to do it the right way.
And isn't there a potential for great mischief if a party can stipulate early on in the litigation to facts and then come pretrial say, no, I no longer agree to stipulate to those facts, and simply putting in the pretrial order, giving the judge notice that one party no longer agrees to those facts is enough to undo the stipulation. I mean, it just seems to me to create huge incentives for all sorts of sandbagging.
Right, and I think that's why the appellate courts have said you've got to timely address this. And I mean, you don't want to sandbag a party at the very last minute and change horses from, okay, we have a stipulation, and now I'm backing away from it without, even if you get past the timeliness of it, just the part of it where now I'm not even going to present evidence as to why I signed this thing in the first place. So I do think that it...
clients protect themselves from that mischief by not consenting to that kind of statement in the pretrial order and then saying, we can't put this in the pretrial order. You already stipulated that this isn't a fact in dispute anymore.
So where's it going to go? I'm thinking if it doesn't go in Schedule E, which is the parties disagree about classification, I mean, where does it go?
Well, I would say you've got to schedule a hearing for the court and say this is effectively a motion to withdraw a stipulation, and we need to have a hearing on this because it needs to be resolved before I can agree to this pretrial order.
Except the pretrial order was entered the same day as trial. And might it have been more prudent at that point to say, okay, we need to hear this before the pretrial order, but that wasn't done. And that's literally at the 11th hour.
Why isn't the trial court's finding that the racetrack road property was defendant's separate property? Why isn't that an implicit allowing of the motion to set aside the stipulation? I mean, the trial court was aware of the motion, right?
Presumably he was, Your Honor.
And the trial court certainly understood that it couldn't hold that the property was defendant's separate property if it accepted the stipulation as valid, right?
Right.
And so how is this not an implicit granting of the motion to withdraw the stipulation?
Because to withdraw a stipulation has to be based upon facts that relate to the formation of what is, in essence, a contract at the outset. It's not we're going to look at the merits of the case and make this determination. Stipulations, if they mean anything, should mean that they remain unless and until the party who seeks to set it aside files a motion, hears it, and presents sufficient evidence for the court to conclude, based on some contractual basis, that this ought to be set aside. Otherwise, I mean, what good are stipulations?
Well, are we back to the Chief Justice's question about whether this is an issue of law and that courts aren't bound by a party's stipulation as to an issue of law?
I would respectfully say that in the equitable distribution context, when the parties agree to the classification, that the court is bound by it. And if you look through the pretrial order that is part of the record in this case, you've got all sorts of stipulations as to the classification of other properties. You've got automobiles, you've got a trailer, you've got personal property. If parties are not able to stipulate as to classification of property in an equitable distribution case, I'm not sure you could ever have a pretrial order, and I'm not sure you could ever complete an equitable distribution case in fewer than, even a small one, in fewer than 2 or 3 days. And I would just respectfully disagree with that, and I may not be correct about that, but it's done every day in equitable distribution hearings. Parties, and it's encouraged. And judges say, we're not going to even try an ED case unless you've got a pretrial order that has all these schedules, what you agree upon in terms of classification, otherwise, and those issues you don't present evidence on them because you've already got a stipulation. And then the court subsequently accepts the stipulation, enters an order based upon what the parties contend or agree is either separate property or divisible property or marital property or whatever the classification is. And Your Honors, I see I'm down to about 2 minutes and 22 seconds. Are there any other questions before potential rebuttal?
Thank you, counsel.
Yes, sir. Thank you.
We'll hear from the appellee.
Good afternoon, Chief Justice Newby and Associate Justices. My name is John Knuckles, and I'm also from the Pitt County Bar. It's my privilege to represent Dale Smith, who's the defendant appellee in this matter. The Court of Appeals properly affirmed the trial court's decision regarding the parties' equitable distribution claims, and in so doing found that the trial court gave due regard to the parties' multiple stipulations, to the evidence that was presented before the court, be it documentary evidence or testimonial evidence, and due regard to the counsel's arguments at the hearing. In doing so, the Court of Appeals and the trial court found that the issue of the stipulation that had been entered into in January of 2019 should be set aside and was properly set aside by the trial court within the containment of its equitable distribution order. I've had the privilege of going second today, and I've understood what some of the questions are with regard to the seasonably filing of the motion to set aside that defendant Dale Smith did in August, the same month of the equitable distribution trial. I would suggest to the court that that's not any sort of ambush or sandbagging. In fact, had it been, the plaintiff's counsel at the time had one failsafe that he could do to ensure that that wasn't the case. He could object. He could object to the entry of the pretrial order. Instead, he signed off on it. He could object to hearing the motion to set aside the earlier stipulation. Instead, he not only waived objection, but he suggested the process and the manner by which the trial court should go about dealing with that motion to set aside the earlier stipulation within the realm of trying the equitable distribution case itself on that particular day.
So one way to frame your friend's argument is that what was actually going on in the pretrial order was just that the parties were acknowledging that the court hadn't yet ruled on the motion. And so there was the possibility that this was going to become an issue in the trial, but that your friend is not abandoning your friend's client was not abandoning the position that the stipulation was binding. So why is that the wrong interpretation of what happened there?
Because she did abandon her position. She didn't come into trial court in the pretrial order and suggest that the property should be marital property. She didn't suggest that the property in the court should be bound by that stipulation in the pretrial order.
But wasn't that the whole point of it being on a schedule where they disagreed over whether, if she had agreed that it was no longer marital property, it wouldn't be on a schedule that said they disagreed over whether it was marital property?
Well, what she could have done was object to the entry of the pretrial order. So it presupposes that the pretrial order, my friend suggests that the pretrial order was forced upon her. It was not. Her counsel signed the pretrial order. They submitted it in the same discussion in which plaintiff's counsel is saying to the court, there's this pending motion. We also need to address it as well, and we can address it today, right in the framework of this equitable distribution trial.
So I feel like I hear you saying two different things. So on the one hand, it sounds like you're saying, you said the trial court found that the stipulation should be set aside. And that's very different from saying that she waived her objection to no longer being bound by the stipulation. And on the first point, where in the trial court's order would we find any explanation of the reason why the trial court was exercising its discretion to set aside the stipulation?
I would continue to be found in finding of fact 12.
But the finding of fact 12 doesn't mention the stipulation, doesn't say, I reviewed the stipulation, I've heard evidence that it was entered into based on a mistake of fact, a mutual mistake of fact. I find there was a mistake 2 years ago, therefore there's grounds to withdraw the stipulation. There's no mention of that.
No, but what it did do is it chose the alternative path. And really that's in essence what the court had before it that day. You have the court either making a decision that the stipulation January of 2019 in fact controls, and so it's marital property, or you have the later stipulations by the parties in the pretrial order along with the defendant's motion to set aside the earlier stipulations. And if the motion to set aside is allowed, then it naturally flows that you're going to follow the stipulations in the pretrial order.
But suppose we read the pretrial order to be a stipulation that there is a disagreement now. Not that she's agreeing that it is not marital property, but just that she is acknowledging that there is now a disagreement over the classification of that property. Then how does the acknowledgement that we disagree give the trial court a basis to say, okay, therefore I'm not going to abide by the stipulation?
I think that the pretrial order did more than acknowledge that there's a disagreement. And I would point to the fact that the plaintiff herself changed the characterization that she wanted the court to address the particular property in from the stipulation, she said it was marital, to the pretrial order, she's now contending it's mixed. And plaintiff's counsel said as much in his opening statement, wherein he talked about the fact that there was commingling of assets and that this property Racetrack Road was used as collateral to create marital debt, and that he would have to ask more questions during the trial to get a feel for what part, if any, might be marital versus separate or mixed.
But
So she changed.
well,
his
I'm
as
looking at
well.
page 105 of the record, the
Yes,
the
ma'am.
pretrial order. This property is listed on Schedule E, is it not?
It is.
And Schedule E says disagreement as to classification.
That is correct.
So she's not saying, I agree that it is not marital property. She's acknowledging there's a disagreement now.
That ignores what's actually in Schedule E, where she contends that it's mixed, not marital. She also contends, and I think that there are stipulations involved in Schedule E where both parties continue to agree to the value of Racetrack Road, and they also have entered into a further stipulation regarding the distribution of a property. So Schedule E does act as stipulations, further stipulations between the parties, and does acknowledge that the parties are now coming to court with a very different position regarding the character of the property than they had in this stipulation. Not just the defendant, both parties.
If the parties both believed that the classification of the property was still subject to the stipulation and was not at issue, where in the pretrial order would you have put that entry?
Schedule A1.
So isn't that the fact that parties consented to put it in the disagreement category and not in the agreement category an indication that they changed the stipulation?
Correct.
If one party was trying to unilaterally do that, like your client did when moving to withdraw the stipulation, that would be one thing. But the pretrial order is the parties helping the court understand this is what we agree to and what you're going to have to decide at the trial.
The pretrial order is a set of stipulations that serve the same purpose as any stipulation, to promote judicial economy, to narrow the issues, and to find agreement where they can with and between the parties. And that's what's truly at issue with this particular stipulation going back to January of 2019. And I would contend to the court that the defendant properly raised the issue in a manner that allowed for the plaintiff to contend with the motion to set aside, separate and apart from the pretrial order. Plaintiff's counsel just chose not to do so. He waived his objection in two ways. One, by entering the pretrial order that said something very different, stipulated something very different than the earlier stipulation. And two, in his comments to the court upon coming back from a conference where he discussed what the conference had been about between the attorneys and the judge. And in that discussion, acknowledged that this motion was pending and that the court could just hear the evidence about the parties' stipulations, plural, that the court could then hear the evidence that the parties have about the property and make its own determinations as to whether to follow the earlier stipulation or the later pretrial stipulations. That's what plaintiff's counsel suggested. Defendant's counsel in his opening statement went along with the manner and process by which the court could continue on, but argued that the property was clearly separate property. Then the parties got into it during the evidence in chief. I would take issue and have to respectfully disagree with my friend Mr. Duke that there was no evidence concerning this stipulation or this property at Racetrack Road during the course of the trial. On page 196 of the trial transcript, the defense... Let me back up, if you don't mind. On page 40 of the trial transcript, plaintiff's counsel shows the January 2019 stipulation to his client, the plaintiff, and proceeds to ask her about it. So here's the stipulation. It's in evidence. It's not being disregarded by the trial court. And plaintiff's counsel asks the plaintiff, that's a filed copy of the stipulation that you have and Mr. Smith signed? And she answers yes. And then he goes on, and she kind of interrupts him the way the transcript the way the transcript reads. And he says, in relation to And Ms. Smith says, the valuation of the properties being Persnickety Lane and Racetrack Road. And Mr. Lambert, trial counselor for Ms. Smith, says, right. Now, here's the golden opportunity for the plaintiff and her counsel to say, what else did the stipulation intend to achieve? That question wasn't asked. Nor did Ms. Smith on her own volunteer that this January 2019 stipulation was intended to resolve the character of the property. Mr. Lambert goes on with his own client on direct plaintiff's examination at page 96 of the trial transcript. He hands her the Schedule E of the pretrial order. Do you see the entry for 4080 Racetrack Road, Grifton property? Again, the property in question. She says, I do. He says, okay. And now, prior to your marriage to Mr. Smith in 2002, to your knowledge, did he owned that property before he married yourself? Is that correct? She answers yes. At no point during the marriage did your name, to your knowledge, get added to that deed to the track, to that Racetrack Road property. And she answers, it did not. It's clearly this was not marital property. The only way that it could be found to be marital property is through the January 19 stipulation. But plaintiff herself has addressed the fact that that stipulation was only intended to deal with value. Plaintiff's counsel went on after that to submit a tax property sheet that also showed the same stipulated value to Racetrack Road property, the $46,000 plus, and also showed that Mr. Smith was the sole owner of the property. On cross-examination of the plaintiff, defendant's counsel, page 128 of the transcript, shows the plaintiff the deed to the property to Racetrack Road. She's again asked if the defendant ever conveyed to her a part of Racetrack Road, and she answers, no, he has not. Defendant's counsel then moves to introduce the deed, and the plaintiff's counsel does not object. In entering the pretrial order, the plaintiff's counsel could have objected. In entering a deed, the plaintiff's counsel could have objected if that was an issue that had already been resolved by the stipulation. He chose not to. He basically opened up the entirety of this evidence for the court to make its decision based on the evidence that was presented to it, not based on a hypothetical of you only have the stipulation itself. So by waiving that objection, the court can assess, well, is this really marital property or not? And it's clear from the plaintiff's own testimony that it's not marital property. On direct examination of the defendant, the defense counsel on page 196 of the transcript asked, and that was your sole and separate property, referring to Racetrack Road. Defendant answers correct, and that has remained your sole and separate property since then. Defendant answers correct. Have you ever deeded any or part of any Racetrack Road to her or anyone else prior to your sale of the property? No. And it had never been titled in her name, and the defendant answers correct. So you have testimonial evidence from both parties supporting the fact that this is not marital property in the definition of marital property. You also have plaintiff's statement that the earlier stipulation was only intended to value the property. That's consistent with the pretrial order, because if you look at the pretrial order, the stipulated values by both parties on Schedule E is the same as the stipulated value with regard to the January 19th stipulation. The defense counsel later repeated that basic question on page 213 of the transcript. And again, do you understand that Ms. Smith is coming to court saying that she has some marital interest in the Racetrack Road property? Some marital interest, meaning marital mixed, whatever the case may be. He does not say that she is saying that she believes the property is strictly marital property. The defendant answers, I understand she's claimed that, yes. And the defense counsel says, okay, have you ever deeded it to her in any way? And the defendant answers no. The court heard that evidence. It saw the deed. It saw the property tax sheet that plaintiff's counsel submitted, saw the pretrial order stipulations, it saw documentary evidence that would support defendant's motion to set aside the earlier stipulation as to the marital character of Racetrack Road. And it also supported the court's finding that the property was separate. So in finding of fact number 12, the court stated specifically that it utilized the stipulations as contained in the pretrial order. The documentary exhibits the admissions and the statements of the parties and the counsel in open court. The testimony of expert witnesses and the testimony and evidence of the parties in the record, which the court determined to have the most credibility or weight on such issues. In essence, he's saying, I find this set of evidence to be controlling and not the stipulation. Our friend from the case earlier today talked about a model of clarity. I would concede that it would have been much clearer for the court than just add another sentence on to say, I don't find the January stipulation to be credible and I'm setting it aside. He did not do that, but the operation of this ED order does the same thing. And as we know, the court does not have to make an exhaustive list of findings, nor does it have to make findings about the findings it didn't make. And that's exactly what would be happening.
So is your position that essentially the parties in the pretrial order entered a new stipulation, and so there was no need for the trial court to rule on the motion to withdraw the earlier stipulation? Or is your position that the trial court effectively did rule on the motion?
Both. And I know that that's basically taking two positions at one time. I recognize that. But the trial court has to make a decision and doesn't have the opportunity necessarily to sit back and wait for weeks or months and doing its own research and making a decision. He ruled on the things that were before him. Did he need to rule on the things before him is what I hear you asking me. And I would suggest to the court that he didn't need to rule on the motion to set aside because the parties have in essence set aside the stipulation already by entry of the modified stipulations in the pretrial order. However, he did, because by hearing evidence of the stipulation, that stipulation went into the record. The defense counsel didn't object to it, didn't argue about it being reviewed by the court. So the court had both in front of it and made a decision about what evidence it found to be more credible. Again, based on the party's testimony about Racetrack Road.
Does it matter if we can't tell whether the trial court thought it didn't need to rule on it because there had been a subsequent stipulation in the pretrial order?
I don't think it does. And the reason that I say that is that if the court thought it was ruling on it and did so by operation of this equitable distribution order, it resolves it. If the court thought it didn't have to rule on it and didn't, but yet put forth this equitable distribution order, it resolves it. Either way, it resolves it. Because at the end of the day, this property clearly was not marital property. The only way you get to there is by holding that the stipulation was not replaced by the pretrial order or set aside by the court.
So let's say that one of the parties testified, and during that testimony, they stated a value of property greater than what was in a stipulation to their advantage. Isn't it incumbent upon the party that wants the stipulation to control to object and say, Your Honor, we object. There's a stipulation in the record that should control valuation. not the testimony of this witness.
Absolutely. And so I've started off with the pretrial order and the fact that the plaintiff's counsel didn't object to the entry of the pretrial order and state that the stipulation controlled that particular piece, Schedule E. But then you have multiple opportunities when defense counsel is either cross-examining the plaintiff and in fact, in this case, submitted the deed to the plaintiff on cross-examination. The court and plaintiff's counsel didn't object to that procedure. So he submitted documentary evidence that would be in contrast to the earlier stipulation. And then he questioned his own client about the property and the characteristics of the property that goes against the stipulation and submitted documentation to his own client. So there were multiple opportunities for plaintiff's counsel to object to the evidence coming in about the pretrial order and about the character of these properties, and he did not do so. And so he's waived the opportunity to object to it now. The interesting thing about that sandbagging argument made earlier is that it is a real concern that parties may enter into a stipulation at one point and then find out what the decision is, and that's happened as a pattern in multiple cases that are cited in our briefs, finds out the decision, then takes issue and tries to attack the stipulation. And of course, that clearly is not seasonable, and the party shouldn't be allowed to address that. In our case, just the opposite has happened. Defendant filed the motion to set aside the stipulation well before the pretrial order was entered or the equitable distribution hearing was had. And it's only after the plaintiff sees the result of the equitable distribution order that she now complains that the manner in which the court went about dealing with these issues was incorrect. But it was her own counsel that suggested the manner in which they went about dealing with both issues. There's a second component to this, but it stands wholly on the Racetrack Road property stipulation, and that is that Judge Arrowwood found that finding of fact 34 related to 50-20 C12 couldn't stand on its own 2 feet, because if the stipulation controlled, then the parties, the defendant did not have separate property that he put into the marital, into the that he did not take out the loan on his separate property because it wasn't his separate property. And I would argue and contend to the court that if you find that it was his separate property, as the trial court did, as the Court of Appeals affirmed, then that goes away on its own accord. But however, even if you found Judge Arrowwood to be correct about that, finding of fact 34, you can break it down into 3 separate parts. Only one part of finding of fact 34 deals with the defendant, the separate property, and the HELOC. The court also had part 1 of that finding, which indicated that the defendant inherited stock from his grandmother when she died. Shortly after marriage, he sold the stock to pay for the marital home. It's clear to the court that this was a gift to the marriage, and the marital residence is marital property. That's not in dispute. Part 3 was that the trial court found that plaintiff contributed none of her own monies towards the marital home. My friend contends that if this Racetrack Road was marital property, she did contribute part of her own money to the marital home. But I don't believe, and I would suggest to you that in reading the entire order of the trial court, her own monies doesn't mean separate and your share of the marital. It just means separate. He used that term, your own monies, in regards to the defendant's separate property on multiple occasions in the order. So even if the Racetrack Road property were found, hypothetically speaking, to be marital property, plaintiff still didn't contribute any of her own monies towards the marital home. So 2 out of 3 of the issues still support that finding of fact 34, that there are sufficient facts and evidence to support that. Additionally, there's 2 other factors that the court addressed that would support an unequal distribution of property. As this court knows, it only takes one of those factors for the court to find an unequal distribution of property. At the end of the day, the trial court addressed all of the issues that were in front of it, taking into account all of the evidence that was in front of it. Could the plaintiff had objected to some of the evidence that it heard? Potentially, but that's not the case that's before you today. In this case, the plaintiff's counsel asked for the court to handle it in this manner. The court did what plaintiff's counsel asked, and then the court made findings that are consistent with either setting aside the stipulation from January 2019 regarding just the character of Racetrack Road, or found that the pretrial order sufficiently addressed the parties' current contentions as their evidence would support as well, that plaintiff thought that there might be some mixed character in Racetrack Road, and defendant clearly thought that his property at Racetrack Road was separate. So in sum, if there's no more questions, I would just say that the plaintiff asked for it to happen that way, and the plaintiff's counsel got what he asked for. I would just like to say thank you for allowing me the time to speak with you today. I appreciate you listening.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. So what my friend Mr. Knuckles is asking the court to do is to create a new way to set aside a stipulation. That would be stipulation being set aside by waiver at trial. To my knowledge, there's no case authority that says that that's something that can be done. Analogize this to a different kind of case. You've got a stipulation that the plaintiff contends defendant ran a red light. There's a stipulation to that effect. There's a trial, there's some equivocation as far as that, and now somehow the testimony at trial attempting to prove certain factual elements in a case is now going to take precedence and override basically a stipulation. I don't know that that really is the proper way to undo a stipulation. Now, we are all guessing from some of the questions that Your Honors have asked. We're guessing what the trial court did. The trial court, I would submit, has a duty to be clear about what it did, what it considered, what it didn't consider. But it all goes back to the same red letter law, I would submit. When there's a stipulation, there has to be something affirmatively put forth to set it aside. Was not Ms. Smith's burden to go in and preemptively talk about a stipulation that is there. The defendant, who of course testifies second, he's certainly free to come in and talk about the stipulation and why he did it. Again, as I said at the outset, people can stipulate about all kinds of things. There may be factual accuracy, there may not be. But a stipulation is binding. It's to be encouraged by the courts. It's to ultimately and long term to make cases more efficient. Now, certainly in this one, it did not do that. I would ask the court to find that there was no consideration by the trial court of the stipulation that was controlling, and ask the court to reverse and send it back down to Pitt County for a new trial. Thank you very much for the opportunity to speak with you.
Thank you both.
All right.